Hello students, welcome to this course of international law, and you're going to have very great knowledge from this course. We are going to look at how international law works and some of the articles. So the first chapter we are going to look at under this course is sources of international law. And the purpose of this chapter is for you to understand the foundational legal rules and principles that govern the relationships between states and international actors. And this is by identifying where international law originates and how it is applied globally. So these are the objectives for this chapter. So let's have an overview of the sources of international law. So the sources of international law are those rules and principles based on which international law is discovered or created and evolves and develops into binding law and amongst all the sovereign states. So unlike our domestic legal systems, where the sources of law can be ascertained with a greater degree of certainty. But the sources of international law involves a tricky question as there is no hierarchical character of a legal order that is with a gradation of authority to make law as it governs the conduct of sovereign states as such. So let us look at how some writers have defined international law. So, for example, in the Black's Law Dictionary, it defines law that it is which is laid down, ordained, or established, and the international law is which regulates the intercourse of nations. The law of and he called it the law of nations. Also, Oppenheim defines international law that it is the body of rules which are legally binding on states in their intercourse with each other. Also, Lord Coleridge also defined international law as the law of nations, is that collection of usages which is civilized states have agreed to observe in their dealings with one another. So the question of sources of law is primo in any system of law, as lawmaking is a continuous process in any viable legal system. So also, Herbert Briggs, pointing the confusion of the term sources, describes it as the methods or procedures by which international law is created. And also, George Schwarzenberg uh, proposed the term law creating process for primary sources, for example, treaties, customs, and general principles of law, and law determining agencies for subsidiary means for determination of law, for example, judicial practice and doctrines. So also Oppenheim contends that there is a difference between formal and material sources. So says that formal being the source from which the legal rules derives its legal validity, and material providing the substantive content of that rule. So generally, the term sources means those provisions operating within the legal system on a technical level. So long before the establishment of UN and ICJ in the 19th and 20th centuries, many treaties and conventions played a great role in development of international law, such as the Geneva Convention in 1864 and Hague Conventions of 1899 and 1907. Also, there was Treaty of Locarno in 1925, to name a few. So also after the establishment of UN in 1948, 45, treaty acquired the most important mode of development of international law. Starting from a Bill of Rights and various sectoral instruments under the United Nations Treaty Series, many thousand treaties have been registered with the UN. So it is also important to note that Article 38 of ICG uh, is generally regarded as an authoritative statement of the sources of international law, although it does not mean to provide an exhaustive list of the sources of international law, but these provisions are in fact expressed in terms of a function of the court. So the first three sources listed, for example, uh, treaties, custom, and principles of law, are sometimes referred as primary sources, whereas the last two, judicial decisions and the teachings of publicists, are referred as subsidiary or secondary sources or evidence of international law rules. So, on the question of preference between sources of international law, rules established by treaty will take preference if such an instrument exists. So it is also argued that international treaties and international customs are sources of international law of equal validity. So let us look at sources of international law in detail. So Article 38, one of the Statute of the International Court of Justice, or ICJ, is widely recognized as the most authoritative statement as to the sources of international law. So the law is applicable in ICJ section 38, 1 and 2. So on the basis of Article 38 of ICJ statute, the following are the distinct sources. So these are the four sources. We have international conventions or treaties. We also have international customs. There is also general principles of law. And lastly, judicial decisions and ratings of the public. So let us look at international conventions or treaties. So treaties are known by a variety of terms: conventions, agreements, pacts, general acts, charters, statutes, declarations, and covenants. So the creation of written agreements whereby the states participating bind themselves legally to act in a particular way or to set up particular relationship between themselves. So also looking at customs as a source of international law. So the Article 38 1 of the Statute of the International Court of Justice also recognizes international customs as a source of international law. So the International Court of Justice's statute refers to international customs as evidence of a general practice accepted as law. So elements for making custom as international law include duration of state practice, also the uniformity and consistency in practice, also the generality in practice, and also opinion juris or acceptance of practice as law. So, so let us look at some views regarding customary laws. So opinion one is customs can't be significant today as source of international law because it is too clumsy and slow moving to accommodate the evolution of international law. Second opinion is that custom is relevant in present day also as it is dynamic process of law creation and more important than treaties since it is of universal application. Let us look at the importance of general principles of law as a source of international law. So the general principles of law are based on justice and equity. Also, they include basic principles of law which are indisputable. Also, general principles of law provide a mechanism to address international issues not already subject either to treaty provisions or binding customary rules. And international law has no method of legislating to provide rules to regulate new situations. So also let us also look at judicial decisions of international tribunals and the ratings of the eminent jurists. So Article 38 also recognizes the judicial decisions as a subsidiary source of international law but not an actual source. So Article 59 of the Statute of the International Court of Justice also provides that the decisions of the court have no binding force except between the parties in respect of that particular case. And while the doctrine of precedent does not exist in international law, one still finds that states in the disputes and textbook writer court judgments of the Permanent Court and ICJ as authoritative decisions. So also the laws of specific state and decisions of municipal courts are not in general and the sources of international law since they do not create legally binding obligations for other states. Also, Article 38 of the Statute of ICJ also recognizes the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of international law. So lastly, let us look at the hierarchy of sources, that is from Article 38.1 of the Statute of the ICJ. So this says that any treaty provision existing between the parties to the dispute must be applied. And also, if there is no treaty, then a rule of international custom. And also, if there is neither a prevailing treaty provision nor a custom, then general principles. So also, in the absence of any of the foregoing judicial decisions and ratings. So these are the further reading materials for this chapter. In case you want to make more research, please use these materials. That's all for now. Thank you.